So hi and welcome to our Wednesday webinar. Burkitt Long is offering a series of fortnightly webinars on a range of different subjects for individuals, families and businesses. I'm Jonathan Perlmutter and I'm the Head of Intellectual Property at Burkitt Long. And this week the topic I've chosen is going back to the roots of IP and learning the basics. And so we're looking at introductory rules related to patents and registered designs. And I'm going to give a presentation now, and actually it's a pre-recorded presentation. And then afterwards I'm going to pop up at the end, possibly wearing a slightly different shirt. So please make use of the Q&A facility and I'll have a good think about your questions. So, what we're going to do today is we're going to look at some of the rules and requirements for patents and designs in order to understand what they are and how they fit with different items. You know, you might have a particular object that you've invented or designed and we need to work out what the best protection there is for that. And in doing that, we're going to have a look at the key features of a patent application or a design registration. And then finally, we're going to understand whether one or the other might be appropriate, or whether more than one thing might be appropriate. And that's one of the major things I want to really stress and emphasize today, is that a particular object that you create can be the subject to lots of different forms of intellectual property, and they overlap and they provide protection for different aspects. So we move on to the next slide. So by way of an introduction, next slide. I'd first like to consider the similarities between patents and designs because there are a lot of them. And the first thing we need to say is that they're both registrations. So you have to compile a document of a particular form with different sections, and we'll come back to those different sections. And then you have to submit them, and then they're dealt with by a particular authority. And then at the end, provided that you've fulfilled the various criteria required, you get legal rights in the creative product. So those rights might be a monopoly over the use of the item or the production of the item, and that monopoly might be transferable, licensable, saleable to others. You might be able to get a loan against it. It might have some value, or you might be able to, certainly in the case of UK patents, get a tax break relative to it. So there's a number of things that you can do with these items, with patents and with registered designs. So my second point is a little bit obscure, I suppose, in some ways, but intellectual property registrations are a kind of a deal with the state and with the public at large. You know, you as the inventor, the designer, the creator, you've come up with this idea, and you have a choice as to whether you can keep it to yourself and therefore deprive the world of the creative genius of your invention, and therefore prevent the progress of the sector at large, or you can share it. And if IP registrations didn't exist, then you'd just be sharing it and people could copy it willy-nilly wherever they liked, really, provided they had the apparatus to make the product or do the method. So what the deal is, as such, is if you can get an intellectual property registration through a design registered or a patent granted in a particular jurisdiction, then you're able to restrain others through the courts from doing things, you know, and that gives you something back for sharing what you do. So, you know, technology marches on, people get to see what you've made, they get to read about it in the patent publication, published specification, or in the design specification, and they get to stand on the shoulders of what you've done and create inventions that may take inspiration from what you've done. So that's what I mean by there being a kind of a deal related to the disclosure of patent or design information. And then my third point on this slide is that they are administered in the same way, and I suppose that's been implicit in some of the things that I've said already, in the sense that there's a process for both of them. There's an application to be made. There are discrete stages that have to be gone through in order to get to registration. And in the case of a design registration, and certainly in the UK and in Europe, that can be quite a truncated process. You make an application, the drawings are checked for clarity and whether they're formally correct, and then they're published, and very soon after they're registered. So in terms of the US, there's actually a bit more involved in registering a design, and there's more examination information that has to be provided, and there's a formal examination process, and confusingly they actually call them design patents there. And in contrast, you've got the stages of making a patent application, which again involve filing an application with different sections, but here of course, as well as some drawings as in a registered design, we have a number of different written parts, a description, a summary of the invention, and importantly some claims which describe the monopoly you're seeking by specifying different features of the invention. But the following stages involve an examination in terms of novelty, i.e. is the application literally new, an inventive step? Is the application or the invention as described in the claims inventive, by which I mean to say, is the part that's new non-obvious? So is it more than just substituting a square peg for a round peg? And various other formal checks are made before registration, and there's also a formal opposition period during which third parties can object and file submissions to say, well, actually, hang on, this isn't new, or maybe it's not inherently patentable, or it's not inventive over what they've done. So it's a bit more of an involved process and a lot longer, and we'll come back to that later on. I think also one thing to say here is that both the patent, when it's granted, is time limited. It has a limit of 20 years on it, as does the design registration, which can last for between 15 and 25 years, depending on the use it's put to. And that should be contrasted with a right like a trademark, which, provided you renew it, can go on forever. And the reason for this time limitation is that it goes back to this idea of the deal. So we swap our secret, our creative secret, for a period of these legal rights, and after that period has expired, then the the invention and the way of doing it is free for the public to use, and thus people can utilize these older inventions later on, and designs indeed. And you wouldn't want that to happen with a trademark, because a trademark's raison d'etre is that it denotes where a set of goods comes from, you know, and that needs to endure, and so that's not time limited. And I think another point to make here is that both designs, in terms of their registered form, and patents are national rights, and so when you make an application, you're usually making it through a national intellectual property office, you know, or a regional one. So, you know, obvious national ones might be the German one, or the UK one, or the US one. But then equally there are some regions. So there's a European patent office, which is very popular with our clients. There's a Eurasian one. There are 2 African ones. And likewise, there are national and regional offices related to designs, although they're not necessarily the same in all instances. But these national rights are overlaid by international systems, and this is very important, you know, especially if you're new to patent applications. So both designs and patents are subject to something called the Paris Convention. And the Paris Convention is very useful. It's an international treaty, over 100 years old, because it provides a number of rights when you make a first filing in a given country. Now, most but not all countries are members of the Paris Convention, and certainly the UK is, and certainly most of the countries in which we make first filings customarily are. And one of the rights that the Paris Convention provides is what's called a right of priority. This is very clever. So when you make a first application, you are afforded rights all over the world, in all of the other Paris Convention countries, for a period of time, and in the case of designs it's 6 months, in the case of patent applications it's 12 months, and during that period you've got provisional protection in all of those countries of the world, provided you do something about it, and by that I mean make a follow-up application within that priority period. So you know, if you filed a UK design, you've got 6 months to file the US one, or if you filed a UK patent application, you've got a year to file the European one, or at least that's the case if you take the Paris Convention on its own. I'm going to come to another treaty in a minute, and that can be very useful because it will allow you to stagger your costs a little bit and not have to do everything at once. I mean, imagine if you wanted to file in a lot of countries and you had to do them all in the same day, you had to get all of your translations ready and so on and so forth. It would make things very, very difficult indeed, and would probably mean that actually you had to wait for a while in order that you could do all of these simultaneous filings, and that would delay you, and it might put the newness of your invention in jeopardy, and of course that's a criterion for getting something granted. So the priority system is very useful because you can make just one application and then that'll do you in most of the countries of the world for that priority period. Now, in terms of patent applications, I want to talk about one other international system, and excuse me if we appear a bit stuck on this slide at the moment, but there's a lot to say about it. But the patent application system also has a further treaty called the Patent Cooperation Treaty, or PCT, and that's very useful, particularly when you use it in conjunction with the Paris Convention, because it allows you to further delay those international filings. So the way that the PCT works is that, as with the Paris Convention, there are a number of signatories. I think it's approaching 160 now, so most of the countries, again, that you're likely to want to file in. And what you can do with the PCT is you can either file it as an application, an international application, or you can use an application that you filed during this Paris Convention period, so within 12 months. And you can make this international application, and that will count for a further 18 months in all of the countries that are signatories. So usually what we do for people, and particularly if they're smaller businesses or they're in some way experimental and they're trying to work out which jurisdictions they're likely to want to file in, we might string a Paris Convention application for 12 months together with a PCT application, and then give them a total of 2.5 years to explore their markets, work out who wants these things, are there prospective licensees in different jurisdictions, can we set up a supply chain here, who's buying the item, is there an export market to tap, does this have this invention have a particular application in a particular country we didn't understand, does it have an appeal there? And they've got 2.5 years to work that out, which is, a reasonable portion of the product cycle, and certainly a lot less than a lot more than no time, and a good chunk more than just 12 months. And so the PCT allows you to have a look at your invention from the perspective of an international examiner during that first 18-month period, and then subsequently, and I'm glossing over a lot of detail here, but subsequently then make applications in the different countries and regions you may want to. And there's also an international system for design registrations called the Hague system, which I'm not really going to dwell on today, but it allows you to make multiple applications in one go. And then we've got the final sort of sub-bullet point on this slide, which is that infringement is examined in the courts. So, as I say, going back to this deal, you're given some rights when you get a registration, and then it's up to you to enforce them, and they're legal rights, so they're enforced in various courts, and they're usually enforced in national courts. There are specialist courts, of course, such as IPEC in the UK, but they're national courts, and they're general legal mechanisms. So you might go to the High Court, and if you didn't win in the High Court, then you might go to the Court of Appeal, and so on. All right, next slide, please. This slide is really just to illustrate the way in which things overlap. When comparing and contrasting things, and you can get the impression that there's an either-or choice, and that's not really true with IP. You have lots of interlinking things, and it's important to link those things together in order to come to a full suit of protection. I wanted to say a suit of armor. So we can see here we've got a kind of a telephone here, haven't we? It's sort of a bit like an iPhone, but it's got some fairly duff-looking buttons at the bottom. And what we've got here is some patents, maybe in the software inside, the user interface, probably battery technology in there that's patented, data processing methods, lots and lots of patents on a world-beating phone, I would think. We've obviously got some trademarks, on the brand, Sorry, we know what the phone is. It's a Nokia 208. I just thought it was a knockoff iPhone that someone had made up. Sorry, Nokia. And there might be a trademark on the music or something like that as well. Just looking at the copyright in the software, and maybe in some images as artistic works and so on. Some trade secrets there probably as well, in-house knowledge that we don't know about, black box stuff on the cloud. And then relevantly to what we're talking about today, and overlapping with the patents, is the way in which the thing looks, and is in the hand, the ergonomics, so the overall form of the phone, arrangement and shape of buttons, and the positioning of the screen. These are all aspects of design, and actually there can be a little bit of overlap. So clearly there are some designs that have an aesthetic aspect, and they have a technical aspect as well. And so you can get technical features from the ergonomics, and they might be patentable. I mean, for example, we quite recently did some work for a device, smoking substitution, where we had a particular shaped mouthpiece, and there were technical functions to the shape and the size of the aperture, for example, the way it fitted in the mouth and so on. And they also had eye appeal, and there were other aspects, the way it fitted in the hand, which were kind of a technical character, but also were aesthetically appealing. And so we had to look at design protection there, and also patent protection. Can we have the next slide, please? Just looking at registered designs in a bit more detail. Next slide, please. We're looking to protect how something looks rather than its functionality. So just going back to that idea of the smoking device, there can be 2 layers of protection there. And thinking about the telephone example, we can protect the 3-dimensional design, so the form of the phone, but also the 2-dimensional patination, decoration as well. And I'll show you a famous pattern in a minute, and you'll see what I mean. That's a pattern as opposed to a patent. Okay, hopefully not an easy mistake to make, but something that sometimes people mishear me on the phone when I'm talking about these things. So we can protect the 2D and the 3D. As I say, there can be some overlap, and overlapping with the technical features protected by a patent, but also we can have for example, a decoration or a pattern which also acts as a trademark as well, and I'll show you one of those in a minute. Or it can also have copyright in the design as well, so it started off life as an artistic work, and then it became mass-produced. Usually, registered designs are quick and easy to get. So provided you have sufficiently decent and detailed drawings, you can obtain the protection in the UK and in Europe very quickly. Less so in the States because of the formal examination process. But in the UK or in Europe, we can usually get these things through to you, through to registration and through to you in about a week or 2 weeks. And so they can provide you with some quick provisional protection. And the last thing, which I think is important, and this is going to be a contrast with patents, which I'm just going to explore in a minute, is that the monopoly is visually defined. So apart from a title and maybe some numbering of the figures, the monopoly is purely in the drawings, so you're protecting how something looks. You know, you don't provide an additional description. So the next slide, please. These are my two examples that I'm going to use. We've got a psychedelic Louis Vuitton pattern on one side there, and we've got actually only a part of a Lamborghini on the other side. And you know, obviously these two designs are very large features of my life. You know, I'm a Lamborghini driver. I dress head to toe in Louis Vuitton. You know, that's how we roll in IP. And they also provide good examples, so you know, everyone's a winner. So we've got here this repeated pattern. It was used on a range of Louis Vuitton bags. I think they still use it, but between 5 and 10 years ago it was very popular, probably a bit later looking at the date. You can see that it's a surface pattern. You know, it's not a three-dimensional thing. It's registered, and it also features the very famous initials, the LV there, which of course is a trademark. So we've got a design containing a trademark, and there's no doubt some trademarks for that LV. Yeah, just looking at some of the data here, we can see that in this instance, it's a European one. It was, and its first language was French. We can see that the application was made in October, and it was published and made effective on the same day. Sorry, it was made effective on the same day, but it was published somewhat after, probably because they were delaying the publication for, you know, so the launch wasn't scuppered. And you can see that it's effective and it will expire in 20 years' time. Looking at the other panel, what we've got here is I don't know the model of the Lamborghini. I think it might be the Hurricane or something like that, or the Aventador maybe. Sorry, I don't know my Lamborghinis so well. I was fibbing when I said that I had one before. And what we've got here is we've got just a very small aspect of this. This is the bit that they're looking to get protection for here, and it's that little orange panel there, which I think is a heat sink or an exhaust or a grill of some sort. And actually I got this from a series, so there's a number of different, let's call them Aventadors, with different panels that are highlighted. And what they're trying to do here is they're trying to get distinctive registered design protection for each piece. And the reason they're doing that is that they want to say this piece is the subject of a registered design, in order to provide them with a lot of ammunition against people who might be making spare parts, or they might be cloning the whole thing, you know. So looking at this, we can see that it was originally filed in German with a second language of English. It's a European one again. It's going to expire in 2022. And actually, this is probably better for my purposes of showing how quickly you can get something through, because you need to publish something before the protection is ascribed to it. But you can see the application was made on the 10th of September 2007, which was also my 27th birthday, and it was published on the 20th. So a very short period of time before the protection was afforded to Lamborghini for that. Can we have the next slide, please? Okay, so now we're thinking about patents. And next slide. Okay, so I'm going to go through this relatively quickly because I'm aware that I've already been breaching the half-hour stage with my ramblings. So and I want to obviously provide time for questions. So in contrast to designs which protect the way something looks, patents are protecting the way an item works. And there are various things which we can protect with patents. Anything of a technical character that isn't disallowed in terms of non-patentability. So generally something might be a product, might be a process, a way of making something. You can actually see in my examples here, we've got an old one, which is the Wright brothers flying machine, and then next to that, probably a bit difficult for you to see unless you really put your nose up against the screen, but that's actually the patent application for one of the coronavirus vaccines. It's either Pfizer or Moderna, I'm not sure. But so we've got two very contrasting products here. We've got a flying machine, which, although not particularly attractive, we can say that it does have an aesthetic aspect. And then we've got something that you can't see at all, a vaccine, biotechnological invention. But they both have a technical character. One thing about the information in these patent applications, and there are certain exceptions to this, and I should also say this isn't necessarily in contrast with designs either, but generally we want to be filing patent applications prior to their public disclosure, because generally they'll be not new for the purposes of patentability if that happens, and that will create a great deal of difficulty if patents are subsequently desired. So my fourth point there is that there's overlap between patents and designs and other things, and I think I've explored that one pretty well. And then also we've got this examination process point, which I covered earlier on really, but there are certain things that aren't patentable. Non-technical computer software, business methods, certain sorts of games, certain forms of biotechnological invention, cloning aren't allowed in the UK. Some of those vary in other places. Landmines, I don't think, are allowed still. So there are certain things that aren't patentable, and then the rest, they have to be new relative to all of the things that have gone before. What we call the prior art, everything that's been publicly disclosed, and the bit that's new has to be inventive. It has to involve an inventive step over what's gone before. It has to be not obvious in the light of prior public disclosures. And finally, and this is a contrast with the design registration, there's a lot of writing in patents. I know it sounds very trite to say it, but a registered design has got some drawings, and that's what the protection is. That's the monopoly. Does it look the same or similar as the copy? But in patents and in patent applications, you've got a lot of description. And then you've got this section at the back, which are these technical statements called claims, which define the monopoly. So, the claims are what are examined, and at the end of examination, when hopefully you get something granted, those claims are what you're using to say, well, is this flying machine, is this coronavirus vaccine, does it involve the same technical steps, the same features as expressed as integers of this claim? So that the claims, the language of the claims is crucial and definitive of the monopoly that you get. And then next slide, please. Okay, so that run through brings me to the end of the presentation here, and I've got a few things to say now. So before we take questions, I should say that we will be sending a recording round to everyone that signed up to today's webinar tomorrow morning, and I hope, if this talk hasn't immediately provoked questions in you, that you'll feel like you can contact us and ask us some more detailed questions. And I think that in the light of the fact that I've said, you know, you need to keep things away from public disclosure, if you want to speak about things specifically, you know, it's a good time, you know, to do that subsequently. Just looking at this slide, we're also going to include in that recording, you know, the email that we send, a link to a very short feedback survey, and we'd really appreciate it if you could complete that so we can make sure that our future webinars are helpful to you. So, as I said at the start, finally, this is one in a series of Wednesday webinars. Our next webinar is an employment law update. And if you're interested in our future webinars, please visit our website or our Eventbrite page to sign up. And so now we'll take some questions.